All right, we just had Hurricane Helene come through, and we've been stuck in the house, and we lost power and everything. But it's sunny out, so I'm outside for the first time in a couple of days. Normally, I just go back to Michigan when the hurricane comes through, and it's always a nothing burger. We seem to be in Jacksonville. They all seem to go around, but this time it was kind of serious. We lost power and everything, so who cares? But we have a really cool thing today. Someone asked me in my last video, the Dirty Socks video, there it is, what is linchpin litigation? And that's a great question because it is everything. Why do I say everything? Because isn't using their own documents against them, isn't the counteraffidavit everything? Yeah, and guess what that's based upon? The linchpin of their lawsuit. So the short version of our title today is Find the Linchpin of a Collection Lawsuit to Kill the Collection Case. So in the last video, the Dirty Socks one with Spring Oaks, I showed you how in certain parts of a lawsuit, every collector lawsuit has a linchpin. So let's say there's 12 allegations, 12 paragraphs, 1 paragraph, 2 paragraph. There'll be 1 or 2 that are the linchpin of the litigation. I want you to get that in your mind. Definition of a linchpin is, and this is what I have, Cindy put it up, a linchpin is the pin that goes through an axle of a wheel. What's that got to do with litigation? The wheels of justice, maybe. But linchpin can be used to mean an important part of anything that holds it all together. So, in other words, if this 1 paragraph or this even 2 paragraphs in a lawsuit, if a collection lawsuit is missing, the whole case falls apart. So that's the linchpin of their lawsuit. So what I want you to do is, I always say, tear the thing apart, look at their pleadings, look at their documents, and in the pleadings, find the linchpin. The linchpin is, it'll say, we own it, here's why, see the bill of sale, or see the assignment. Sometimes that's the only paragraph that means anything. And I'm going to show you, as I showed you in the Dirty Socks video, here it is again. 10 seconds, let's do this. So we have a linchpin of every collection video. So if you just got a collection video, as I always say, have your pity party video. Collection lawsuit, have your pity party, go, now come back fighting. First thing is, we take their lawsuit and we break it apart. Say it's 12 paragraphs, find the linchpin. The thing that if it was missing, then the axle would break down, the wheels of justice would go in your favor, or the whole thing would break apart. Keep in mind, you should look at it this way. Remember, we talk in terms of a chain of title. This is that. If you have a missing link or a weak link, the chain is only as strong as that. It's the same thing with lawsuits. If you have a weak part of it and it's the linchpin, you win. It's that simple. So, Cindy, put on the screen our 4 goals today. Find the linchpin and find a way to win. What is a linchpin of a lawsuit? Just like a chain of title, it's as strong as its missing or weakest link. Find the linchpin, kill the case. And then lastly, what does the debt buyer tell you? It depends upon it to its own detriment. Those 4 things are really one and the same. Where's the linchpin that kills their case? So let's take a look. Our first case is a Calvary case. Cindy put it on the screen. The first 5 allegations of the lawsuit, Shazam. Yeah, we did this. Yeah, we did that. You're this, we're that. Here's the amount you owe. So that's fluff. That doesn't prove anything, okay? So now we go, we put on the screen, Cindy, the next part of this. I think it's 11 count, 11, oh, it's 13 paragraphs. Put it up there, Cindy, Shazam. And now, what's the linchpin of those pleadings? So there's 13 pleadings, and the linchpin here is number 6. Cindy, put it right up there, just 6. That on May 20th, 24, the account at issue was transferred, sold, or assigned from Citibank to plaintiff. See the bill of sale. So without that, the case doesn't exist because you have not shown an assignment. So that's the linchpin. So let's look at their linchpin. Keep it up there again. That on May 20th, the account at issue, by the way, it's not an account at issue, It's a debt. Why can't you just say debt if you own it? Transferred, sold, or assigned. Well, was it transferred, was it sold, or was it assigned? If you own it, you say, I bought it, I own it, you owe it. That's very simple. Why make it harder than it is? So look at the bill of sale they point to. So Cindy put up the bill of sale, Shazam, and you'll see there's a signature. First of all, they're saying that they are sending, in the last second paragraph bottom, they're assigning accounts. That's got not your name or not your client's name. That's not the biggest thing here that we're attacking. Look at, in this case, the signature of a Terry Bergman. And Cindy emphasized just that signature, Shazam. Okay, so first of all, authorized party, who authorized it? You've got to have proof that you have the right to sign this. There's no date, there's no certification. But as I counseled before, everything is hearsay. And until you get an exception, it's not coming in. Most exceptions for debt collection lawsuits are your state, which is, let's say you're in Montana. I think it's MRE, Michigan Rules, well, if it's Michigan Rules of Evidence 803-6 would be the exception why a hearsay document is coming in. Everything is hearsay unless proven otherwise. So hearsay is defined as an out-of-court statement offered to prove the truth of the matter asserted. So if it's out of court, which a bill of sale and assignment here is November 23rd, November 2023, that's hearsay, got to come in the business records exception, but it must be certified, must be signed, must be proper, must be authorized. None of that exists. But the most important thing here is, and I feel weird showing you this, but this is what happens in my business. Cindy put up other signatures of this Terry Bergman. All right, see the difference in the other signatures versus Cindy, if you squeeze up the original signature, Shazam, and then look side by side at the other signatures of other documents of Bergman. I do a lot of Citibank litigation, mostly debt buy, where the debt buy bought Citibank stuff. So I see Terry Bergman or Brandy Reardon all the time. You'll see one of those, and no matter what state you're in, you'll see either Terry Bergman or Brandy Reardon. So there's plenty of signatures to compare. I did, and look what I found. That's gold, Jerry, gold. So that goes into your counter affidavit along with the other ways you break down their pleadings. Attach this video at my membership site, collectionstoppersolutions.com, will be the affidavit I used to focus on the linchpin and the answer. So my plunking video, check that out. You take what you put into the counter affidavit, it plunks into the answer. It plunks, plunk alert, plunks into the affirmative defenses, and if they don't settle this within 7 days, plunks into the counter claim. Here's another, by the way, that was a Calgary lawsuit. It's another Calgary lawsuit. Cindy put up the fluff. First we see the fluff and then the stuff. Shazam, and that's the fluff. We're this, you're that, we're a limited company, who cares? And also notice they're saying we're debt collectors, a collection communication. Again, a little quick, I always like to throw in more than you pay for. So under FDCPA, a debt buyer or debt collector is immune from their pleadings being a collection communication. You want that so that, because anytime you make a first collection contact with a debtor, you have to supply them with their validation and verification rights under federal law within 5 days. But the FDCPA at 1692 GD says pleadings are not a form of collection communication to initiate the requirement of validation. But they threw in, this is a communication from a debt collector. They killed their own immunity and they killed their client's safety. And now I put right in my counter affidavit, you see, hey man, you got to validate. They won't. Now you got another claim against them. So, but look at number 6 in this case. Put it up, Sinsky, and there you go. They're saying Unifund, this is a Unifund, sorry, it's not a Calvary case, a Unifund, has all right and title and interest of the account as evidenced by the bill of sale. Go to the bill of sale, Cindy, Shazam, and see that signature compared to those others? Oh, what tango webs we weave. Anyway, so we focus on that as a linchpin. So number 6, again, is our linchpin that we got to knock out, and we can clearly knock that out. By the way, it isn't telling you that your debt or anybody else's debt is passing with this, what they call a bill of sale and assignment. It's neither. And it's also dependent upon the master purchase and sale agreement, the forward flow agreement, which is not attached, even though the whole thing is subject to those terms and conditions. So they're moving accounts, not debts. Those are important things that you will find in the counter affidavit attached to this video on this case. So they also throw in a linchpin. Remember I said they have 1 or 2 linchpins? Count was opened on 9/16/2005, and the date of the last payment was 4/12/2018. So that is, that's weird. Anyway, the reason client, rarely does a debt collector say, you made the last payment. They just don't, unless they're really close to the statute of limitations of the state they're in. So my client assured me he had not made a payment on this debt in at least 7 years. So why would the debt collector point this out? Because they're, how do I put this? They're saying stuff, anytime someone volunteers something bad news, why would they volunteer something you don't usually see in lawsuits? Because they're trying to claim they have a right to sue my client. So I have him sign his counter affidavit. That'll be attached to this video along with the answer. So you put everything in the counter affidavit, the linchpin litigation aspect, plunks into the answer, plunks into the counterclaim, as I said. Want to see another one? This one is a Calvary lawsuit. This time you're going to do the work, all right? So I'm just going to put up the complaint. You tell me where the linchpin of this litigation is. Ready? Cindy Shazamsky. All right, let me hear. Come on. What? You're right, number 3. Why number 3? Well, it says that on 12/31/2015 in this lawsuit, and up top the plaintiff is Calvary, plaintiff entered into a credit card agreement with defendant. Well, that's impossible. Plaintiff Calvary is a debt buyer. It wouldn't have gotten into this case until a debt was purchased, not initiated. It would be, in this case, they tell you right up top, we're an assignee of Synchrony Bank. See, up right underneath the words complaint, leave it up there, Cindy. So they're clearly telling you plaintiff is Calvary, we got it from Synchrony Bank. Yet number 3, the linchpin of their case says 2031, we entered into the credit card agreement, an impossibility. You knock that out, you kill the head of the snake, you kill the snake. So that's your linchpin. They did not say in this case that there was even an assignment proof. So, but let's just quickly look at it. Cindy put it up, Shazam. And that's your old friend, Lynn Fisher, telling you, it's not true, but we're going to use this for a reason, that on 11/29/2023, she wore a lot of hats, a lot of titles, and doesn't swear under oath that all these many entities in this bill of sale all passed the debt without any reference to the debt or even your or your client's name on 2023. So if that is when Calvary first got the lawsuit, the debt, as they are clearly saying in their own documents, then how did on 2015 plaintiff Calvary enter in credit agreement? See how you killed that? So that's your linchpin right there. Paragraph 3 is your linchpin. So the paragraph 3 is your linchpin of the lawsuit to attack in your what? Counter affidavit. And where do we plunk that into? Oh, you're so good today. Right into your answer. And if they don't give you a settlement that you like in 7 days, yes, correct. Right into your counterclaim. So with this video, by the way, like, love, and subscribe this video, and have some fun, keep rocking. And go to my membership website, collectionstoppersolutions.com. I will put 3 counter affidavits in Word template, all that are part of the linchpin litigation. Remember, linchpin litigation kills their case. I'll also put the 3 answers that I used in these cases, where the counter affidavit information was plunked into the answers and then plunked into the counter affidavits, and then I believe in at least 2 of these cases, they settled within days. One of these is a brand new one, which again, as I always tell you, I like to give you actual cases that I litigate so that you can see the actual work that needs to be done. Use your state rules, your evidence rules, your facts. I'm not telling you how to love or to law, but I am telling you to like and love and subscribe. Thank you. And go to the membership website. Still got that $99 discounted price for a month of, I think, 180 videos, a community aspect, all the documents that you would need if you're going to self-represent. I hate pitching like this, but it's so good, I'm thinking of joining. Yeah, I do join. So there you go. The linchpin of litigation. Keep that in mind. It's part of your counter-affidavit and tearing their pleadings apart and killing their case. Thank you. Go Tigers. They're in the playoffs. Thank you. Bye.